With my videos, I normally do a daily tip where I give you a very concise piece of information about a common topic that I see clients or other people encounter. The how-to series, which I'm doing right now, is I try to do once a week. And actually, just give me 1 second. I want to adjust my audio here. Okay, this should be good. I do my how-to series once a week where I go a little deeper into what I call like a medium topic, a little larger than I get to do my daily topic, but so you get a little more substance. It usually take like 5 or 10 minutes. Then I do each month, every other month or so, I do a webinar where I do like an hour on the topic. So today's how-to series is how to understand why you won't get sole custody. And that title may seem a little odd because I'm talking about a negative when people are usually looking for how to become successful with something. First, I probably did a tip like that before, but more importantly, it's very important to know that you probably will not get sole custody. And I'm asked this question all the time. I get clients who come in all the time, potential clients asking for sole custody. And it's very challenging when you're speaking with somebody who's a prospective client and they don't know any experience or history that you may or may not have, and you're telling them that they can't get something. A lot of people think you're not willing to fight for them. A lot of people think maybe you're just not qualified or the right attorney. And it's really important to know the limits of the law before you start blazing in the court and asking for something. So let's jump right into the topic. First, to understand why you won't get sole custody, I think it's important to understand what it actually is. Now, basically speaking, there are two types of custody. There's legal custody and there's physical custody. And you can have sole legal physical custody or joint legal physical, or you can have sole legal custody or joint legal custody. And there's physical custody. You can have sole physical custody or sole physical custody or joint physical custody. So let me go back to that one more time. Sole and legal are separate. You can have sole legal, you can have sole physical, you can have joint legal, you can have joint physical. Usually you're going to have joint both. Or you're going to have sole both, but again, chances are you won't get sole. Legal custody deals with who makes the important decisions for the child. Education, religion, residence, relocation. Those are going to be the major decisions that a person with either sole or joint physical or joint legal custody will be making. Physical custody is the amount of parenting time the other parent has. So even if the other parent has an hour of parenting time over the course of a year, that's still going to be considered joint physical custody. But that's probably not that important. The people that seek sole custody are seeking more of the legal sole custody. They want the ability to make decisions without input. They want to be able to relocate without any problems or having to go to court. So the information on this series is geared more towards that area, not the physical custody area. So let's talk about why you're not going to get it. And to understand that, you have to understand the different layers of laws that apply to a custody case. It's not just a best interest of the child, which we'll get to. First, you have to look at the constitutional area of law that says a parent has a fundamental constitutional right to a relationship with his or her child. So while it may seem easy for the courts to intervene in a custody case, that's only because you're giving them that right by bringing it to a court. But fundamentally, you have the right to a relationship with your child and have it unhampered from the court. So first, you have the constitutional issue that you have to overcome. Second, there's a presumption of fitness. In most states, and even in New Jersey, where if you are a parent to a child, you're presumed to be fit to parent that child. It's the other parent's responsibility or the court's duty to find if you are unfit, but they have to overcome that burden that you walk in presumed to be fit for custody of your child. Then there's an underlying psychological belief that pervades the courts right now, and that is that any child benefits by having both of his or her parents involved in his or her life. Now, New Jersey used to have what's called the tender years doctrine, which I don't know if it's technically been overturned, but I think it has been. At least it's been rejected. That law used to say that a child was best served with his or her mother. And that was based on the psychological belief at that time that a mother was more nurturing and better capable of parenting a child. That's been replaced. So the current New Jersey law, it's important to understand, has an underlying psychological current that states that a child is benefited by having both parents involved. So you need to overcome that issue also. Next, you have to turn to the actual custody factors in New Jersey. I'm going to actually go through all of them. Now, there's many. Normally, I wouldn't do that because it's kind of tedious if you're listening to this video and trying to get some quick information. But I'm going to give it to you in case you do have a custody case coming up of any type. You can quickly get this list from this video and be able to use it. So quickly, custody factors are parents' ability to agree or cooperate, unwillingness to accept custody, interaction of the child with parents, history of domestic violence, safety of the child with the parent, the preferences of the child based on the child's age, the needs of the child, stability of the home environment, continuity of education, fitness of the parents, proximity of the two homes, extent of time spent with the child before the separation, employment responsibilities, and the age and number of the children. Now, in order for you to get sole custody, given these factors, you need to be able to show the court that all of these factors weigh in favor of not having the other parent involved in the decisions. Now, just looking at the sheer list of factors, it's nearly impossible, given what I already talked about, constitutional right, the psychological presumption, to be able to take all these factors and be able to show that they point towards having one parent removed from a child's life is next to impossible. If you were even to get to that stage, which again, unbelievable that you could, the next issue would be the best interest of the child standard, which is the standard that kind of applies to everything when you talk about a child. So even though we have, the custody factors I just mentioned, you'll hear things like material and substantial change of circumstances warranting a change of custody. That's all relevant, but all of this is guided by what's called the best interest of the child. Now, this goes against sole custody primarily because, one, it's an ambiguous term. So judges do everything they can to refrain from giving sole custody in the first place because of everything I just mentioned. When they're left with determining a child issue, they can rely on the best interest and say it's not in the child's best interest because there's nothing that says what is and isn't. It differs by circumstance. Next, when you do have issues about the best interest of the child, it has to be that it's best for the child. Most of the time, people that are coming in for sole custody are coming in for reasons like there's domestic violence, there's a lack of communication. But that all deals with the parent. The best interest means it has to be best for the child. So most of the time, the reasons people are seeking sole custody is because it's in their best interest. It makes their lives and communication more favorable and easy. But it's very hard, if not impossible, to show how those issues are actually in the best interest of the child. And remember, the word is best. It's not better or good for or accommodating, but it's best. So you have that burden of showing that it's best for the child. And lastly, there are some circumstances where the law suggests there should be sole custody. One where there's a chronic history of lack of communication and the parents can't work in the child's best interest, and the issuance of a final restraining order. Now, the issuance of a final restraining order actually carries with it a presumption that the recipient should have sole custody. But I still find that most judges will resist as much as possible actually giving that phrase in the final restraining order because of all the reasons I mentioned before. They don't want to do that. So you almost have to, one, go in there knowing that your restraining order will carry a presumption and fight to get that. Even if you do get it in your final restraining order, in my experience, it's been changed subsequently very easily. And again, for all the reasons that I mentioned. So in short, don't expect to get sole custody. If you go to an attorney and you ask for sole custody and that attorney tells you, yeah, let's go, let's do it, chances are you're with somebody who either doesn't know his or her job very well or doesn't really care as much about serving the client as they do as advocating for the client. Well, there's nothing wrong with that. You really should take the contents of this video at heart and ask that person if they really think they're going to overcome everything that I'm mentioning. If the answer is yes, then go for it. If they can't give you that answer, then it's not going to happen, and I don't recommend you do it. I hope this information was helpful. If you did find it helpful, I'd appreciate you giving a like and sharing it so that other people get to see it. I will be on again today at 6 o'clock. I'm going to do my daily tip, which is, again, a much shorter video on how to read tax returns and use them in a divorce. Until then, thanks for coming, and I appreciate the support.